hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and of the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the October 1st, 2024 sitting of the Massachusetts Appeals Court. I'm Justice Eric Nyman. To my right is Justice Sabita Singh, and to my left is Justice Robert Toon. We will be your panel this morning. Usual appeals court rules are in effect. Each side will have 15 minutes to make their presentation. There is no rebuttal. A few more housekeeping matters. First, I would like to welcome students from Massachusetts School of Law who are in attendance today. Welcome. Nice to see you. Second, we go by the clock in this court, which means that you will have 15 minutes, and when the clock turns red, that means you should stop your arguments. If we see the need to give you more time, we will do so, but otherwise that should conclude your argument. Finally, during argument, you will see the judges on occasion looking down at their iPads. I assure you we are not looking at the Patriots news or the Bruins news or anything else having to do with anything apart from this case. We are simply checking the record and the case law and your representations in real time. So with that said, we will call the next case on our list. It is docket 23P1194, Commonwealth versus Parker. Attorney Noonan. Good morning.
Good morning, Your Honors. May it please the Court, Patrick Noonan for Harold Parker. I would first like to start with the last issue, which is the bench warrant issue, which I think is the most important issue raised in the brief and perhaps the strongest one. The trial judge in this case erred when he declined to issue a bench warrant for Officer Velez, who was, I suggest, a necessary witness for the defense. The trial counsel requested a bench warrant, and trial counsel declined to issue the bench warrant. Firstly, I'd like to say that trial counsel was diligent in trying to secure Officer Velez to appear at trial, because there is some suggestion in the record that trial counsel did not do enough.
Well, I think the suggestion wasn't that he didn't secure him ahead of time, but he didn't speak to the officer to actually get an interview, figure out exactly what he would say.
So one of the reasons why subpoenas are issued is to bring a witness into court. You can have a conversation with the witness in court, and you can have a voir dire of the witness if they respond to a subpoena. Trial counsel had also called the Brockton Police Station several times requesting to speak to Officer Velez, and the representative answering the phone said, "We're not even sure if he's going to show up for the trial," something to that effect, because trial counsel wanted to make sure that Officer Velez would appear. So,
is that in the record, that there was a representation that we don't know he's going to show up?
I think the actual reference was that trial counsel called the police station to see if Officer Velez would appear at trial, and I think it said that the police department said they weren't sure or they didn't know whether he was going to appear at the trial.
There was evidence too that the prosecutor tried to get.
The trial prosecutor also got on board, which was a very nice thing for the trial prosecutor to do at the beginning of the trial once we were alerted that there was no response. She indicated that she reached out to the police prosecutor to try to secure his presence. So the trial prosecutor wasn't able to secure the presence either. But getting back to Justice Singh's point, I don't know what else defense counsel could have done. I mean, this was a patrolman. I know from experience, patrolmen don't really keep office hours at the police station. They work shifts. So it would have been difficult to have an in-person meeting with Officer Velez, considering he's a beat officer, doesn't hold office hours.
There's a process in some counties, not all do this, but there's a process in some counties whereby the police officers are made available to defense counsel to speak with them about the case. Is that a process that is used at all in Plymouth County in your experience?
I can say, practicing criminal defense in Plymouth County since 2011, I haven't heard of that policy, and I've actually had cases in Plymouth County where I've actually spoken to detectives prior to trial and asked, could I speak to you about the case? And the response I get is no. And the other response I typically get is, I'll answer any questions you have on the witness stand. So My efforts to speak to officers in Plymouth County have been unsuccessful. I've had several cases where I've tried to do that. I'm not sure. Maybe the district attorney can speak to any policies that Plymouth County may have for talking to officers, but having left messages for Officer Velez and not getting a call back, and I think that a party has, some sort of expectation that a witness will appear pursuant to a subpoena, particularly a police officer. So if there was a question as to the relevancy of his testimony, at least responding to the subpoena would have got him into court. Trial counsel could have a conversation with him in the hallway.
Yeah, what is the process if say, the police officer does not want to respond to what are they supposed to do, other than assuming not just ignore it? What's the process to go into court and move to
It's a
quash,
subpoena.
or-
It's a subpoena. If they feel that if they get a subpoena on a case and they say to themselves, I have no idea what this case is, I have no memory of this case, my testimony is not relevant in this case, they can certainly move to quash. And certainly, if Officer Velez said to himself, like, I don't have anything to offer on this case, I looked at my police report, I have no memory of this, he certainly could have talked to legal counsel for Brockton PD or even the district attorney's office. They could have moved to quash and say his testimony is not relevant. So I think trial counsel had a reasonable expectation that this officer would appear in court for the subpoena, and he didn't. And then I would also say that Officer Velez was a necessary witness for the defense in terms of he was necessary to present an adequate defense. And necessary witnesses are usually defined as a witness who would provide relevant material testimony that is non-cumulative. So the trial judge, in the beginning of the case, there was a motion to eliminate where trial counsel got into Officer Velez and what he would testify to, and trial judge said, okay, that's relevant. And then Officer Velez doesn't show up and the defense says he's not here.
But the point was to show, that you're saying this was a necessary witness. The point of this witness was to establish that the complainant in the restraining order had made a prior false allegation of violation.
Yes.
But the facts that were being tried right now, the restraining order violation was in the nature of a video.
Correct.
And the jurors had the video.
Correct.
So it wasn't necessarily he said, she said that would rely on, you understand, this wasn't her simply making a claim that there was a violation. There was an actual video, something tangible for the jurors to look at to determine whether a violation occurred.
Sure. What I would say to that is, obviously, when she's a complaining witness, so her credibility is a huge issue in the case. If that evidence came in, the light most favorable to the defense, let's say that evidence came in and Officer Velez said, yeah, this alleged victim called up, reported a violation, turned out to be false, the jury still had to credit her testimony that, A, it was the defendant in the video. Because it's a 5-second video, they don't show his face, there's words uttered, so they would have to credit her testimony that this is the defendant who sent me the video. If she's got credibility issues, maybe the jury would have said, we're not really too convinced with her that it is actually him in the video. And the other issue for her credibility would have been the defendant sent me this video and that it was sent to me on a certain date. So
I'm sorry to interrupt.
Sure.
So you wanted this information essentially to impeach her on what is something of a collateral issue. Collateral in the sense that it's not about this crime, it's about a prior allegation of crime.
I would say that it was not collateral. One of the analogies I would kind of liken this to is sort of like maybe like a Bohannon type of situation where you have a rape allegation
Good
and
analogy.
a prior false rape allegation, and we have a 209A violation and what I suggest is a prior false 209 allegation. So I would say that it's not collateral. I would say that it's essential.
But you wanted it for impeachment is the point.
For two reasons. One, for impeachment, because she said in her testimony that I didn't speak to the officer.
And presumably the officer might come in and testify. Might, we don't know, might say, oh, I do recall speaking with her.
And what I would say about that, Your Honor, is when the trial judge looked at Officer Velez's police report, he did say that he spoke to all the parties at the house.
And then spoke to the two brothers, yes.
Yes, but it was including the alleged victim.
It seems that you're relying on the de Grenier case here. That's one of your better cases.
Yeah, that's one of them.
And de Grenier involved, my understanding is the police officer in that case was a precipient witness to the crime itself. And in this case, the police officer is not a precipient witness. How does that impact your analysis, if it does at all?
I don't think it impacts the analysis because the officer is not going to be testifying to what he saw. He's going to be testifying to what the alleged victim reported to him. And then
About a different incident at a different time. So at least it's not as strong as de Grenier. I'm not saying de Grenier doesn't control. I'm just
Right.
saying it presents a slightly weaker situation.
Yeah, de Grenier is definitely stronger where an officer is a precipient witness, but
Counsel, in this case, is it clear who made the call to the police?
oh,
In the incident that you're talking about, the prior,
no, just the only thing we have on that, Your Honor, is Velez's police report. That's Record Appendix 31. It just says he was working the uniform patrol when responding to the address for a violation. So it doesn't say who called 911.
but the report itself only lays out the substantive statements of the two men at the house. So the report itself doesn't really indicate that she called the police, that she made an allegation of a violation, that she claimed to have seen the defendant there.
Right.
So
Yeah.
it could easily be that one of her brother, her boyfriend, might have seen somebody and thought it was the defendant.
And that's what the trial judge said, which was, I can't see that there are any statements attributed to the victim in the report, but
But
What I-
the argument becomes more tenuous when you can't really establish that it's a false allegation then, that it's her false allegation.
well, if we were prepared, we had the second witness, the probation officer, ready to testify that Mr.
That's
Parker
only
was-
relevant if she's the one who made the call, right?
Right. And that's why we needed the officer to come in, because the officer does say in the police report that he did speak to the alleged victim on scene when he's investigating this case. And what I would say is that it is reasonable to infer that the officer had to have spoken to the alleged victim, because she's the victim of the restraining order, she's the plaintiff, and he's investigating a violation of a 209A. He's
But
at
isn't
the
the most
house.
relevant fact, if you're trying to establish that she made a prior false allegation, so isn't the most relevant fact who called? Who was motivated to call the police to say there's a violation? I'm intentionally making a false claim to get him into trouble.
Right.
So that would be her call. If it was her mom who called, wouldn't that be different?
Well, I mean, if the 911 caller is the only person who saw this person supposedly show up, then I'd say yes, the 911 caller is the main person. But there are three people in the house, and they all have information. And just because, let's say the alleged victim didn't call 911, she still could have been interviewed at the scene by Officer Velez, and he could have asked, what did you see, what did you hear? And she could have said, yeah, well, I heard him at the door saying tisk tisk, or I looked out the window and I saw his car driving away. So you're absolutely right. It's a good point. If she didn't call 911, that's certainly something that doesn't work in my favor, but I think the officer still would have had to have spoken to her at the scene about this. And that's why I think that we need to kind of consider what we do in this particular circumstance when an officer doesn't show up. I've seen cases where a civilian witness doesn't show up and judges really don't mind issuing bench warrants for him, but it seemed like defense counsel just really didn't have any sort of relief or any remedy when the officer didn't show up, really didn't know what to do at that point. The trial had already been underway, the Commonwealth had already rested the case, so we're mid-trial and the officer wasn't here, so, and then
Can I
just-
ask you about, and I'm going to ask the district attorney's office about this as well, but what was the evidence that this video got sent to the defendant?
Yes. So the testimony was the alleged victim testified that her mother called the police to report a violation. That officer, Officer Goby, went down to her house and spoke to the alleged victim, and it was reported that the defendant sent her a Facebook message and also had sent her this particular video.
Right. And
Then
the video was attached to the Facebook message? Is that?
That's a good question, and it's ambiguous in the record.
I mean, I'm trying to get to what, the Facebook message is digital evidence. Digital evidence needs to be authenticated.
Yeah.
And I'm trying to understand what evidence there was that this Facebook message was sent at this time.
There was none. In the office,
No screenshot, no internet record?
Nope.
Was there any evidence that established that where the message was sent from?
Never, none. And Officer Goby testified that he went to the scene to investigate, he didn't look at the Facebook messages, he didn't seize the Facebook messages as evidence. He testified when he got there he didn't even watch this video, testified that he didn't issue any search warrants, testified that he didn't review any paperwork, no Facebook messages.
Was there any evidence about the defendant having a Facebook account?
No. And then I had asked...
How is this consistent with the Williams case, where it deals with the MySpace account, and there has to be confirming circumstances to establish that the defendant was the author of the communication? And I'm just trying to get my head around what the evidence was to support not the video, but the authentication of the message whereby the video was sent to the defendant.
And there was none, because Officer Goby was asked, did you get a search warrant for Mr. Parker's Facebook? Did you verify that if he had a Facebook account? And then there was no testimony from the alleged victim, like, we usually correspond on Facebook. The message I got on Facebook was in the username H. Parker, which I'm used to, communicating with him in that way. But she didn't provide any statements.
The victim testified at trial,
Yes,
and she identified the video, which was admitted into evidence as an exhibit, correct?
yes,
Okay.
yes. But then Officer Goby was asked, did you have any evidence at all as to when the Facebook message was sent or the video was sent? And he said, no, I don't. And one of the issues raised is, obviously that they have to prove that the video was sent on a date that the order was in effect. And I'm saying that the only evidence was the alleged victim's testimony in response to a leading question, was this video sent on the same day you called the police? Yes, but there was absolutely nothing else to back it up. And I know I'm not supposed to...
Thank you. We're going to have to leave it there.
Okay.
Thank you very much. Counsel for the appellee. Good morning.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. To start with the authentication of the video.
No, I'm sorry. I'm really concerned about the authentication of the Facebook message. That's the violation. The video is the video, but the fact that the video was sent at a particular time, that's the violation. So I want to get to the authentication of the Facebook message.
The message was the video. My understanding from the testimony, the authentication came from the victim testifying, which is allowable. The testimony about there was no search warrant, the jury heard that there was no other corroboration for that, but it would be the Commonwealth's position that that goes to the weight of the evidence, and that's something that they could consider, and that it isn't necessary to have that.
Don't you need to, this is digital evidence, right? There's all these rules that we have about authenticating digital evidence.
Correct.
One of them is you have to establish that the person was the author of the digital message. And so I'm trying to understand what evidence was there that the defendant was the author of the Facebook message that sent the video. And there didn't seem to be anything in the record. He had a Facebook account. I recognize his Facebook account. I've corresponded with the defendant on that account before. There was nothing. It was just a reference by the victim to a Facebook message. And it seems really unique in the cases I've seen on these kinds of digital evidence issues.
Yeah, I agree with Your Honor. I do not recall any other testimony specific to the victim giving that type of information. Her information seemed to be focused on, I received this video of him masturbating. So I think it was, the way I read the transcript and the testimony from the victim was that I received this video of him masturbating, I recognize him, I've dated him, I have a child of his, this came from him.
And she could certainly seem to authenticate. There was enough to support authentication of the video, but it's the transmission of the video. I think that's
correct. Presumably, the argument could be made that someone else sent the video of him masturbating to her. But again, that would be the trial issue. The argument could be made.
Well, there was a pre-existing relationship, right? So
correct.
People sometimes share videos, right? Correct. But sort of the violation here is actually the transmission on that date, and I'm just trying to find out what else supports a finding that
Right.
the defendant was the author of that message.
I don't believe there's anything else in the record, any more than if she had testified, I received a phone call. He called me and he said this to me. I believe the victim going into court and saying, I received this phone call, he called me and this is what he said. I don't think it would be necessary for the Commonwealth to then put in necessary, it might be helpful, it might be.
Actually, Williams talks about a phone call, and actually authentication is required in that circumstance too.
But-
So it's all the same kind of issue. You need authentication of authorship. Recognizing the defendant's voice is certainly helpful in that regard.
Correct, just like in a
But
text.
here, there was no recognition that this was the defendant's Facebook account, or I've received messages before, or that a Facebook account had his username.
Right, I don't believe she gave that specific detail, as there's also conversations about some of the challenges that she faced. I don't know that she would have necessarily been able to convey that type of information any more than I received this from him.
Right, and there's no screenshot or internet log or anything like that.
Correct.
Yes.
That is correct.
And nothing, the officer himself really couldn't verify any of these details about the message.
No, he could not.
Okay, thank you.
That is correct. Moving on to the the alleged prior incident, just would like to point out that Officer Velez, the subject of the bench warrant issue, he did not respond to a prior incident. He responded to an incident in August of 2022. This restraining order violation was in October of 2021. So just want to clarify, just for the purposes of making sure that it's very clear, that he responded to an incident several months after this particular restraining order violation, and his police report does not attribute any statements to the victim at all. He does not document anything that she said to him or reported to him that created probable cause or was the basis for for the complaint issuing or for anything having to do with the August of 2022. As far as whether or not he was a necessary witness, it was put forward he was a necessary witness to impeach the victim. But there was nothing to impeach the victim about. The victim testified about this incident. My brother called the police. That was what her testimony was. That's consistent. My brother talked to them.
Well,
that was consistent with what...
Officer Velez says in the report, I spoke with the victim. And the victim at trial says, I did not speak with the officer. So that's the contradiction, right? That's established.
It was, I believe the testimony was more specific than that. It was asking about what was reported to Velez. And she made the comment about the brother was the one that made the report.
Yes,
So-
but she said that she did not speak with the officer.
Right.
You're right, it may be collateral, it may be minimal, but there is a contradiction between the officer's report and her testimony in that regard. I think you can agree.
So do you recall telling the officer something about it? And she said, my brother already talked to him. Did you speak to the officer regarding Mr. Parker coming to your house in August? No. So she did not make any allegations about him coming in August, and that's consistent with what Velez wrote. He didn't say she reported this. His police report indicates that the brother is the one that allegedly saw Mr. Parker, was the one that saw him leaving, and the boyfriend made some comments. But the officer did not document, he didn't write that she said, I saw him. She said he did this. He made no statements about her. And so because of that, the trial judge determined that this really wasn't impeachment evidence, that he really wasn't necessary. If you wanted to attack her credibility, that had already been done. That could already have been argued. So that he wasn't a necessary, this officer from an incident that happened months after this restraining order violation, who had no statements in his police report attributed to the victim, was not necessary to impeach the victim.
You know, the judge initially says, prior to trial, that this evidence is extremely probative of the victim's credibility, which the case stands on her credibility. And then the subpoena is issued, and the officer doesn't show up, and the prosecutor calls the police department, nobody responds. And then the judge seems to back off his determination of how relevant this evidence was. But I guess to get to the ultimate question of what's your view as to when the police can just simply disregard a trial subpoena in this kind of circumstance? Do you have any concerns about that? I mean, it seems like the trial prosecutor was concerned and was trying to assist the defense in getting the police department to respond. I'm just curious as what your views are on sort of the police department just not responding to this issue at all.
I have a couple of thoughts. First, in regards to the judge backing off, when it was discussed prior to the testimony coming in, my recollection was that he understood what the issue was and wanted to hear how the testimony came in to determine whether or not it was going to be, in his view, necessary. So it was something that was already brought to his attention and in the back of his mind as he was hearing all of the testimony coming in. Is in regards to officers ignoring subpoenas, whether it's a case that's theirs or regardless, just any subpoena that they received, no, I would say it's not best practice to simply ignore. That it should be something that they should respond to. I'm not aware of any specific policies or procedures. I know that was mentioned as my brother was speaking, that would speak to that. I think a prosecutor, when they're at trial, they're often looked to try to reach out to witnesses that the defense has subpoenaed, whether or not the Commonwealth wanted them for the particular case. I think it's more of a professional courtesy than a statement on what anyone should or shouldn't be doing to assist in moving the trial along.
It seems to me that this is a common occurrence, not necessarily police officers, but witnesses on occasion don't respond to summonses or subpoenas. Sometimes they don't get them, sometimes they ignore them, sometimes they're in the hospital. In any case, aren't there a number of tools available to a judge to deal with this in their discretion? They can grant continuances. They can exclude evidence. They can limit the Commonwealth's case. They can give limiting instructions. They can issue another subpoena. They can issue a court order to arrest the witness. There's a whole penumbra of tools available, right?
Yes.
So the issue that we have here really is whether or not there was prejudice. First of all, whether there's error, and secondly, whether or not there's prejudice. And with that in mind, it seems to me you state in your brief that this evidence wasn't relevant. Isn't that going a bit far? I mean, wasn't this evidence at least potentially relevant to impeach the victim's credibility, pending what the police officer might say?
But it's opening up the door to then what people might say. I mean, the judge asked for a proffer, so they might say that. So to then issue bench warrants and require subpoenas to just bring in without any basis, I think is a slippery slope. At what point would that end? To then come in and say, this person might be relevant.
But isn't it unfair for the judge to deny? I'm sorry, I didn't get to
No, please.
I mean, so the judge doesn't entirely back off his initial determination of relevance, but says, you're right, you haven't made a proffer. But it's on the record that defense lawyers trying to reach the officer, and no one would return his calls, and no one would return the prosecutor's calls. So I don't understand what kind of proffer can the defense lawyer make in this circumstance? Is he supposed to burst into the police department and grab Officer Velez and say,
No.
talk to me? I don't understand. What is he supposed to do to get around this proffer challenge?
I think the judge's point was there's nothing in the police report to indicate that this officer has any information. He's not attributing any statements to this witness. He didn't write anything. If you read his police report, he says, I responded, I met with these people. He's saying who's there, but he doesn't attribute not one statement to her, nothing. So that's where the speculation comes in. So then it opens up the door. So then
Well, there's
are
at
we
least
saying,
ambiguity as to what kind of conversation occurred between the officer and the victim at this later account. as you point
Correct.
out, right. Again, if the Officer Velez was willing to talk to the defense lawyer, maybe they could have figured out
Right,
what that
but-
was and make a proffer. But if Officer Velez won't return anyone's phone calls and the police department won't assist in making this communication, I just don't understand what the defendant is able to do.
Correct, but then I guess the question would become, well, maybe there's a neighbor that saw something. We should subpoena them if they don't show up, get a bench warrant for them, because they might have seen something. They're not mentioned, they didn't say anything, they didn't say, officer, I saw something, but maybe they did, so let's bring them in. And if they don't show up, get a bench warrant, bring them in. Like I think that's where a line needs to be drawn. There was nothing, and I think that's where this judge drew that line. There was nothing in the report, there was nothing anticipated that this officer would say or have to offer that would impeach the victim. There was nothing in his report attributable to her that would contradict what she testified to on the stand. Now, it may have been different if it was the brother that was testifying and you were trying to impeach him and he was testifying what you thought was inconsistent, and then you want Officer Velez there because he clearly has statements attributable to the brother. I think that would be a very different circumstance, but that's not the circumstance we have here, and I think that's why this particular trial judge, after hearing it, after seeing what Officer Velez wrote, and seeing that there was nothing in addition that could be proffered that was any different than that, granted, given that the officer was not returning the phone calls, however,
Counsel,
there was nothing there.
No witness is required to have an interview with any of the lawyers in a criminal case, right?
Correct.
So even if the defense attorney had, done everything, tried to make the contact, and just refused an interview, what you're left with in the end is what you've got, absent an actual interview with a witness ahead of time. And so the proffer was based strictly on the police report, right? That was the good faith basis to go forward, correct?
Correct. So I guess then what the trial judge would be faced with is presumably, if this is a residence where multiple officers have responded to, then presumably every single officer could be brought in because they might have something to say. I think that's a bit too far. When you have nothing, it's completely speculative, you don't have anything, again, to contradict anyone, and it's simply a mechanism for discovery at that point.
And we're going to have to leave it there.
And I appreciate your
Thank you very
time.
much.
Thank you so much.
Thank you both. Excellent argument. The case is submitted.
Thank you.
Calling our next case, Commonwealth v. Diaz, 23P 1462.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to reverse the...
I'm going to rudely interrupt the beginning of your argument, just to ask one preliminary question, which
Certainly.
is, do you take issue with any of the judge's findings of fact here?
No. No. And jumping back into it, we do not. I think here we ask you to reverse the allowance of the defendant's motion to suppress the search of his cell phone because the judge made an error of law. And she made an error of law in two distinct ways. The first was in misapplying Commonwealth v. White, in finding that there was any obligation to obtain a search warrant expeditiously. And the second is how the balancing test was employed. So if the court has no objection, I'll start with the first point, which is White can be distinguishable on its facts. And really the first question, I think, if we're making a guidepost as to how issues like this should be analyzed is, how did the police get it? And so in White, how the police got it was there was no other exception to a warrant requirement other than...
Here it was a search incident to arrest. There was
Correct.
probable cause to seize it.
Correct.
They're good to grab it. They're good to hold it. The question becomes for how long?
The question becomes for how long, but I think it's important, too, to distinguish from some cases that my brother cites, specifically Cruzado, and to a certain extent Barillas, in that in this case, the cell phone itself was an instrumentality of the crime, which makes it different than both of those cases. Specifically in Barillas itself, Justice Cipher notes that there is no allegation that it's an instrumentality of the crime, that it could contain evidence of the underlying arrest warrant, which the defendant was being arrested for. Here, if you look at the specific allegations that existed before the phone was seized, it's that the cell phone itself was integral in setting up these rapes and that it was used in perpetrating the sexual abuse of the victims, and that a flashlight was used and that photographs were taken. So certainly it stands on different footing than any of the cases that my brother cites or any of the...
I'm sorry to interrupt, but you're getting to the crux of the case, at least for me, which
Yeah.
is this. Is it enough that the phone is an instrumentality of the crime? Or under Arthur, must it have independent evidentiary significance standing by itself regardless of the content on it?
Certainly.
And here's the distinction, it seems to me, that you have to overcome. In Arthur, there was evidence, or rather, at least the way the decision reads, is the evidentiary value existed regardless of whether on further investigations the cell phones might contain additional relevant evidence in their digital data. Right? The phones themselves
Yeah,
tended to prove joint venture.
correct.
And that's actually the phones in combination with the officer's observations of them using the phone,
of the two
which were then
cars.
seized by the officer then and there. So even if there's nothing on the phones that matters, the phones themselves can be admitted in evidence at ensuing trial.
Certainly.
Here, it seems to me that without a description of the phone, without that particularity, we need to know what's on the phone before that phone can be admissible in this trial.
Well-
Tell me why I'm right or wrong.
Certainly, and I think that goes to the standard that you're employing at a motion to suppress stage as opposed to later at trial. So I think at the point that it's seized, and if you look at the search incident to arrest law, if you look at the statute, it holds that if they have probable cause to believe it's an instrumentality of the crime, that they can hold it as evidence of the crime. Now, what you're speaking about, there may be some problem with authentication as to the actual item itself later on during trial, but I don't think that that is really dispositive or important for this analysis. But I will say it could be that the defendant had the ability, had a cell phone itself, had a cell phone with a flashlight, had a cell phone that matched a general description. I would say, separate and apart from its contents, it could be used to corroborate the victim's testimony at trial.
That's the case, then anytime the police sees a cell phone that could conceivably have any connection to the crime, the police could hold it forever, and this rule about expeditiously getting a search warrant, that exception would swallow the rule.
I don't believe so, because you would have to have, that's where the that the cell phone itself was an instrumentality of the crime, right? So I think Onyx White is a good example. And
But
Onyx
again,
White,
I'm sorry to interrupt you, but this is really important, at least to me. Is it that it's an instrumentality of the crime, or that it has independent evidentiary significance standing alone? That seems to me to be what we said in the Arthur case.
Correct, and I guess I don't understand how an instrumentality of the crime wouldn't have independent evidentiary existence standing alone. Because if you have a basis to believe that it is an instrumentality of the crime, then independently the object itself would have evidentiary value.
So then all of the cases that say, basically, hey, you took too long to get a search warrant, what happens to all of those? Because some of them, at least in the federal circuit, are cases somewhat similar to this, where the courts have said, geez, the Fourth Amendment says, or contemplates that you've got to get a search warrant at some point in time.
At
within
some point in
reason.
time, I agree with you, at some point in time.
Within reason, and what's reasonable has
certain-
varied.
Certainly, reasonable and varied, but I think the importance is, and I think if you look at those federal cases, they don't have the requirement, not that I can see, that expeditious requirement, right? That language seems to come from Onyx White. And I think Onyx White is a good example, because in Onyx White, at the moment that they got the cell phone, they didn't really have any evidence, aside from the fact that they believed it was a joint venture, to support that a cell phone was used in that murder in any instance. And so the police got it, they seized it, and if you look at the opinion, they say the only possible basis by which they got possession of this cell phone was that they could impound it for the short period of time in order to obtain a search warrant. So in that instance, there is an expeditious requirement. I'm saying that word wrong, but there is a requirement that you get it.
Search warrant be obtained expeditiously.
Expeditiously. Because they say if there is not incriminating evidence on that phone, then it should be returned to the person who had it. If you look at, if you look at a case, again, if you look at the Barillas case, in Barillas case, they say that the Commonwealth did not argue, and there wasn't a basis to believe that the cell phone at the point that it was seized incident to its arrest was evidence of the crime for which there was an arrest warrant for. If you look at Cruzado, that's another case. And Cruzado, again, it's a murder case. A lot of these are murder cases, so maybe they're not the most instructive. But in that case, there was evidence that the defendant made some sort of incriminating statement to a person. They went to go pick up the defendant. When they find him, he's asleep on the ground and there's a cell phone a foot away. They grab the cell phone. Again, in that instance, there isn't the type of information or evidence that is here as to how a cell phone was intricately used in the commission of the crime.
Just to help me understand, say you never got a warrant for the contents of the phone. How would you use the phone as an exhibit to prove the defendant's guilt at trial?
Certainly, so you would have...
What would it show?
Certainly. So you could do it one of two ways. You could, and this certainly would come through in trial prep, you could have the victim and say, is this a cell phone that he used to take these photographs of you? And she could say, yes, I recognize that to be the cell phone that was used to take photographs of me. You could also have the detective who seized it at the moment the defendant was arrested and say, 3 months after this alleged sexual abuse was alleged to have taken place, he was found with a cell phone. One of the victims described it as the cell phones that were used in the perpetration of the crimes were an iPhone, and specifically an iPhone with a flashlight. So you could say, yes, I had this cell phone was of X size, this cell phone had a flashlight, and that could be used to corroborate the victim's testimony. In rape cases, it's really important because a lot of times it's he said, she said, so any evidence that you have that could tend to prove that the victim is telling the truth, even if it is so much as the defendant had a cell phone, the cell phone matched the description, it was an iPhone, it had a flashlight, I think that is evidence that would be admissible and would be properly authenticated.
Judge Ellis seemed to believe that there was some requirement at the suppression stage to tie specific identification of that phone to this case at the suppression stage, and you're telling me that in your view she's wrong. Why?
I think she's wrong. I would say...
On what authority and what cases?
The probable cause standard, if you look at a case like Gentile, for example, if you look at cases in which the probable cause standard in and of itself, which says that it probably has to be evidence related to a crime.
So you're saying if there's probable cause to seize an item and the relevance of that item is dependent in part on the contents of it, the police can wait for in perpetuity to obtain a search warrant?
Well, like everything else with the Fourth Amendment and Article 14, it's a reasonableness test. And I think Arthur has a good articulation of that reasonableness test, which is, and this can be found specifically on page 166, that you have to look at the defendant's interest in the property, and if you find there is no substantial interest, then there is no requirement that the search occur expeditiously, and you weigh what is a low possessory interest against the strong governmental interest and find that the search and the delay that it took to get the search warrant was reasonable.
Let me ask this to you a different way. How do we reverse Judge Ellis's determination without running afoul of Commonwealth versus White?
So I think that's easy. I think in Commonwealth v. White, it's not a search incident to arrest. It's not an instrumentality of the crime. The item didn't have apparent independent evidentiary value. I also think post-White...
What if we find that here, I want you to keep going your analysis, but assume here we find that in this case it did not have independent evidentiary significance standing alone?
I mean, I don't want you to make that finding, I guess, is that ruling.
So in other words, your case is dependent on that determination here? I mean, I don't want to concede points that I don't have to concede. I think it's difficult for me to think of the probable cause standard, which is probably. It's not definitely. It's not that you have to prove it beyond a reasonable doubt at this stage. It's less than a preponderance of the
evidence. It's less
evidence.
of a preponderance of the evidence. That a person has a cell phone that a sexual assault victim has described was used in actually setting up and in the commission of these crimes. That
A cell phone was used. We don't know that it was this cell phone.
And I don't necessarily think you have to prove that it was this specific.
Probable cause that it was this phone.
It has to be probable cause, but I think also if you think of the nature of cell phones and if you look at recent case law, cell phones are durable goods. So there is a basis by which you can believe that that someone was alleged to have had a cell phone 3 months later, it would be the same cell phone. And I don't think that that is a leap. I think that's grounded in recent case law from this court, specifically the John Vieira case, which can be found at 104 Mass App Court 93. So I don't think it's a leap, but I think, too, it's putting too fine a point on what relevant evidence is, especially in cases like sexual assault cases or rape cases where, aside from the word of the victim, really the evidence that you need to corroborate their testimony are things like the defendant indeed had this type of cell phone when he was arrested 3 months later. So I would say I as much as I can wholeheartedly and respectfully disagree that the cell phone itself would not be independent evidence of the crime separate and apart from its contents, I think that yes, because otherwise you're in an Onyx White situation, right? Because in Onyx White, the cell phone itself, based on the circumstances under which, at the time that they seized it, did not have independent evidentiary value, right? They had no real basis, no concrete basis other than a reasonable inference that people engaged in a joint venture use cell phones.
And the phone was seized in July, and the last time that it was used, at least according to the victim's interview, was in March of the same year.
So 4 months later. 4 months later.
What do we make of the fact that in Arthur, the police applied for a search warrant to seize the phones 3 days after the car was impounded, right? So that seems to support, oh yes, these phones are independently important regardless of their content. We're going to go and get a seizure. That didn't happen here. Does that make a difference to our analysis?
No, I mean, it makes a difference to the way that you weigh the analysis. Certainly it's much easier to justify a 3-day delay than a 123-day delay, but I don't think that that necessarily changes. And I think if you look at the actual reasoning in there, Judge Englander did state that there is no requirement to expeditiously even obtain this warrant where it was going to be held until trial anyway.
So is it your position that the expeditious requirement only matters if the defendant has a right to get it back?
Correct. And I think that's where Judge Ellis, and that will be to my second point, which I'm getting to with 57 seconds left, but my second point is when she's engaged in this balancing test, when she's looking at the interest that the defendant has, she's talking about his privacy interest, which is different than his possessory interest.
Right.
And so that's the weighing that has to happen. Certainly, the Commonwealth is not saying that he doesn't have a privacy interest. That's why we got a search warrant. But his possessory interest is different, and when you look at a possessory interest, you have to think about the interference with his possessory rights. And if it's a proper seizure incident to arrest, which there is no ruling that this wasn't a proper seizure incident to arrest, so via the case law and via a statute, the Commonwealth had the right to hold this evidence until trial. Where that exists, you have to weigh that against, which makes the defendant's interest really a non-interest because he couldn't get it back and he's made no attempts to get it back, against the government's strong interest. And when weighing that and applying Arthur, I think that this court should continue to hold and to state that there is no requirement that a search warrant be obtained expeditiously, I'll say it again, and find that the search and the seizure of this item was reasonable in this instance. Thank you.
Thank you very much. Attorney Olson.
Morning, Your Honor. George Olson, if it may please the court. I would say that the motion judge correctly ruled that the period of 123 days was unreasonable. The arrest and seizure of the phone was on July 18th of 2019. The police did not apply for a search warrant until November 18th of 2019. So in White, there are essentially two holdings. They first determined that the seizure of the phone was improper, but they went on to say even if it was improper, the police need to diligently obtain a search warrant.
Well, they said that, but they also said, however, we have never said that that is a dispositive factor.
Well, I understand. So the analysis here, Your Honors, the police officer testified that he put getting a search warrant on the back burner after the arrest. So In White, they suggested, I mean, they said that the police must quickly get a search warrant or release the item. And
So here, do you agree that the seizure was proper?
there's no dispute with the seizure being proper.
Okay. And do you also agree that, set aside the issue of a search warrant for the contents, that they could have held on to that cell phone?
So I would suggest that they had to get judicial review, like they did in Arthur. In Arthur, they applied for a search warrant within 3 days, and the court deemed that there was a justification to hold on to the phone. And the fact that they waited to get a search warrant to get into the contents of the phone.
But this first search warrant was just an effort to show that there was probable cause to actually seize the item, correct?
In Arthur.
In Arthur. Same here. There was, even though they didn't have a search warrant, they had probable cause to seize the item as a search incident to arrest. Why does that distinction matter?
Well, so I
Probable
think,
cause is probable cause, isn't it?
well, I think in White, there needs to be a judicial determination that there is probable cause, that the police can hold on to the warrant. And
Does White
otherwise,
say
they
that?
have to
Does
let it go.
White actually says there must be a judicial determination to seize
Well, that the
and hold on
police
to evidence?
should seek a search warrant. What I'm suggesting is there needs to be a judicial determination that there is probable cause, or the police must let it go, the phone.
Does that go
Return it.
for all evidence? I mean, I'm not aware of this rule that, something that's, you agreed that that there's no dispute that it was properly seized. And at some point, there needs to be
So
a determination that you can still hold on to properly seized evidence?
what I'm suggesting, this is not, if it was marijuana or cocaine, that's certainly different. This is a cell phone where my client has a strong interest in. And I'm suggesting that they have an obligation to get a search warrant or return the phone within a reasonable time.
What if they never intended to look at the contents, they just want to use it to corroborate the victim's testimony?
Well, so the issue here is in the testimony in the motion to suppress hearing. There was no description of the phone whatsoever. There was questions about whether or not it was, there was no testimony as to whether it was an iPhone or an Android or a Samsung or any other phone. There was no description of the phone, what color it was, anything like that. So I think the court was correct to find that the Commonwealth hadn't met its burden, that there was an independent evidentiary value of the phone at trial.
Well, the
at that
search
point.
warrant says, and the officers had information at the time of arrest that the cell phone was used in the commission of several crimes and used to continue to perpetrate these sex crimes up until March of, I think it's 2021, and then in July of 2021, the phone is seized. So that's 3 months later. Why isn't it a reasonable inference that the defendant's phone would still be the defendant's phone?
Well, I think that there's a lot of things that can happen in the 4-month period.
It's probable cause here at this point. We don't have to rule out all the other possibilities. It's just probable cause.
I understand. I think that at this point, as I said, there was no description of the phone.
I spoke a lot there, so let me go back to my question,
Okay.
which is, based on the information that the father used his phone or the defendant used this phone to perpetuate these crimes or perpetrate these crimes through March of 2021, why wasn't it a reasonable inference that the phone seized from his person in July of 2021 was the same phone?
Well, I think it's quite possible that people have multiple phones. There's no showing in the motion that this was the particular phone, and that's part of what the judge relied on. So the judge relied, the
I was
judge
under the
said-
impression that at the probable cause stage, it wasn't incumbent on the Commonwealth to rule out every other possibility. There's always lots of other possibilities in a probable cause determination. So that's where I'm struggling with this part of the argument.
No, I understand, and I would suggest that at this stage, the even if there is probable cause, the police, even if the police believe they have probable cause, I guess is the distinction I'm trying to make, they still have to go before the court as a check to determine, the court to determine whether or not there's probable cause. And that's how I view it. And that's what they did in Arthur. They went before the court agreed there was probable cause, and therefore the client's interest in getting back the phone was much lessened because he was never going to get the phone at that point because it was going to be used at trial. And a court had already said there was the Commonwealth could keep the phone.
Let me ask it this way. And by the way, I said 2021. I believe it's 2019 is the correct year, so I apologize. Suppose at the motion to suppress hearing, the sergeant detective testified that the victims talked to me and they described the phone as this, U.S. Army phone in a black and copper case with this emblem on it. Under those circumstances, would the judge have had to deny the motion to suppress?
I think it would have been. A lot stronger argument for the Commonwealth. However, I still think the Commonwealth needs to. The police need to seek a warrant or release the item.
I guess you may have already done this, but can you just address Ms. Campbell's argument with respect to why she thinks there is independent evidentiary value to the phones themselves, regardless of their content? Do you disagree with her argument on that, and why?
As far as the evidence produced at the motion hearing?
Just in general, like, does the existence of the phone have independent evidentiary value that could be used, that Commonwealth could use at trial to prove its case against the defendant?
Meaning based upon what they found after executing the search warrant?
Based on the existence of the phone, yes. Could the phone be used in an exhibit to prove their case at trial?
So I guess I'd answer it this way. Based on the evidence produced in the motion hearing, I would say no. But that's, after the execution of the search warrant, there was evidence discovered that would have had an independent evidentiary value. But I think for the purposes of this analysis, it has to be confined to the evidence that the police produced and the Commonwealth produced at the motion to suppress hearing. Based on that, I would say no, there was not an independent evidentiary value.
And
So
sorry, go ahead.
You're saying at the trial of this matter, the Commonwealth would not be able to say, we seized this phone on the defendant, and at the time of his arrest, and try to submit it into evidence in any way?
Well, so at that point, based on what happened in the motion to suppress, there was no evidence introduced that the witness had identified this particular phone as the phone that was used. There was no description, anything that would link this particular phone to the crimes that are alleged.
But at trial, you could have a witness give a more particularized description.
If that, but, so what I guess what I'm saying is that would have had to be demonstrated at the motion hearing, that type of showing could have been made at the trial.
So you'd have to demonstrate its ultimate admissibility at trial, you're saying, in order for the police to be able to hold on to this phone.
So, yes, that's what I'm saying.
So you're suggesting at the suppression stage, let me say that again, you're suggesting that at the suppression stage, the Commonwealth needs to have evidence of admissibility at trial?
So, let me just back up.
It needs to meet that standard at the probable cause stage?
What I'm saying to the court is this. When the police seized the phone in this situation, in Arthur, the police did everything right. They had the phone for a certain short amount of time. They got a search warrant to seize the phone, and therefore the phone was going to be in their custody and control throughout all the way to trial. In this situation here, the police believed that they had an independent evidentiary use for the phone aside from its contents. However, they did not seek a search warrant. And I would suggest, based on the law, they had to get a search warrant and apply for a search warrant in a short amount of time. The fact that the police and the Commonwealth believed that it had an independent evidentiary use other than its contents was not demonstrated at the hearing. And they did not apply for a search warrant. So therefore, the judge was right in their ruling. I hope that.
It does answer it. My only question is, it seems to me that the police obtained that first search warrant in Arthur because they were concerned that they didn't have a basis to hold on. It wasn't a search incident to arrest. It was, I think, in essence, abandoned property. So they had the concern that, geez, we're not sure if we have probable cause. Let's just get the search warrant to make sure, unlike the present case where it's clearly a search incident to arrest where that phone was properly seized by the police officer. So I'm not sure that the distinction makes a difference. Obviously we'll give that some thought.
Right. And I would suggest that it doesn't make a difference because under the Commonwealth's argument, there would be no judicial review whatsoever. The police could hold the phone in perpetuity with the court never weighing in on whether they actually had probable cause or determine whether or not they could keep the cell phone from the individual all that period of time. There'd be no purpose for them to get a search warrant whatsoever to seize it if they weren't going to get into the contents. And I just want to say that there is no case that has a time period such as 123 days that was ever found reasonable. There was, I think, White was 84 days, no, 68 days, I'm sorry. In Henley, they found 6 days was reasonable. In Cruzado, it was 10 days that they found to be reasonable. Recently, the unpublished decision, Cedric Williams found that 34 days was unreasonable. I don't have anything further unless there's any.
Nothing further. Thank you very much. This is well briefed and well argued. The case is submitted. We good? Keep going.
If you are.
Calling our next case. Docket 23P1171, Mango v. Board of Assessors of Marblehead. Attorney Rosenthal.
Good morning, Your Honors. Steve Rosenthal for Nicholas Mango. May it please the Court. Whether the ATV's findings were supported by substantial evidence is a question of law, and I refer you to the Towley and Black Rock cases cited in my brief at page 28. It's incorrect, as the appellee states, to say that this is merely a question of fact. I would also ask you to take a look at the Hampton Associates case on page 17 of my reply brief, which I think stands for the proposition that where persuasive evidence is presented by the party with the burden of proof, a presumptively valid assessment requires substantial evidence to support it. There was no substantial evidence in this particular case. What happened was the ATB relied solely on a rebuttable presumption that the assessor's valuation of the unit was accurate. The ATB abused its discretion when it disregarded uncontroverted public records and expert testimony without explaining why this evidence was rejected. And again, there I would ask you to look at the Robinson and the New Boston Garden cases that are in the brief. Glover Landing in 2015 described the fire escape themselves as a life-threatening risk, as extremely dangerous. The town building commissioner issued an order in November 2015 that the fire escapes on any Glover Landing buildings of 3 or more units had failed inspection and had to be fixed in 30 days. There were also orders from the Board of Health to fix the roof leaks within 30 days. None of these orders were observed or fulfilled. In April 2018, the building commissioner found that the egress conditions were dangerous and they ordered remediation.
Can I interrupt? I mean, certainly all these factors that you cite were taken into consideration by the board at some point. I mean, the initial unit was initially assessed in fiscal year 2016 at $900,000. By 2020, it was assessed for half that value, correct? So
That's correct.
I assume some of those factors weighed into the really unusual diminution in the overall value of the unit by the board. But your position is it has to be a zero value? That's the only correct position here, that the unit is worth nothing?
I think
it's really quite extraordinary to argue that and to say that the board erred by not zeroing out the value of the unit for tax assessment purposes.
Well, Your Honor, the unit was uninhabitable, legally uninhabitable. It was
Does no one else live at the condominium complex? Does no one else live at Glover Landing now?
I didn't hear what you
Does
said.
no one else live at this condo complex now?
No one else with those problems lives in that condominium unit or in
Certainly
that
these problems
condominium
are common
building.
to other units as well, is that right? And I guess I don't want to go outside the record
This
here, but
unit is the only one that is directly below the roof, which leaks. And the roof leaks were documented, and this was a situation where over a period of now going on 10 years, these conditions were not corrected.
But other units are subject to the fire escape system deficiencies. Other units are subject to the fire escape system
That's correct. And in
deficiencies.
fact, BCAB, the Building Code Appeals Board, issued an order in July 2022 saying that all fire escapes for all of the buildings in this condominium, trying to think of the right word, in the entire community, okay, those had to be replaced. And there were findings in, in other agency orders that these fire escapes were illegal, they weren't proper.
And that's a serious problem, but that's certainly not a plausible basis to sort of say that all of the value, every unit at the complex has zero value, right?
To answer the question you had a little bit earlier, my take on this is that my clients are saying the property's worth nothing because we can't use it for the purpose for which it was intended. But do we have to prove that it's worth zero? No, we have to prove that the assessor's valuation was inaccurate. And the assessor valued the unit at a value that didn't
Less than
reflect
half
the
of what
problems.
it was before the problems sprang upon them, correct?
Didn't,
Less than half of what the prior assessment had been before these issues came about.
that's true, but that was a somewhat inadequate assessment.
I understand that, but let me get at Justice Toon's question a slightly different way. It seems to me that the trial strategy or the hearing strategy was all or nothing. Would you agree with that?
I have to agree with that.
And I know you weren't trial counsel, and I'm not disparaging that choice. It may have been a perfectly intelligent and smart strategy. But it seems to me that you could have picked, or your client could have chosen a different strategy. They could have had experts and others testify to the cost to become code compliant, the costs of the repairs, showing that everything was cost prohibitive, and perhaps come up with a different value that was significantly lower, but not zero. In other words, in some ways, your clients, I don't want to say increased their burden, but made a little bit tougher sell by saying it's worth zero.
My problem with that, Your Honor, is that my clients had no control over the problems that existed in the common area. They weren't even allowed to conduct any of the repairs. They weren't in a position to assess the repairs that were necessary. And we have a history going back to 2015 of the condo association being asked to make these repairs and then not making them. And we have a history.
They could have still retained an expert to say, here's what it would, here are the leaks, here's the fire escape, here would be the costs to repair all of this, and here's the impact it has on the actual value. And that number could have been something greater than zero, but less than $405,000, for example.
That may be true, but it's still my position that it's not our job to prove that it's worth zero. It's our job to prove that the assessor was incorrect. And the assessor relied on a presumption. And that presumption, and if I can find the case, again, I would look at that Hampton Associates case that I cited to you earlier, okay? There was substantial evidence, substantive evidence, showing the diminished value, the really worthless value of the unit to my clients, or to anybody for that matter, and that would overcome the presumption that the assessor used in this case.
Your clients vacated the unit in 2015, isn't that right?
Correct.
And at the hearing in 2023, they really couldn't even say with certainty whether there was still continuing water leakage to the roof. Isn't that correct?
Well, the purpose of the hearing before the Appellate Tax Board was to determine the conditions as of January 1st, 2019 and January 1st, 2020. And Mr. Mango testified in great detail as to the conditions and the continuing conditions of the unit at that time.
But you're making some, in your brief, you say, there's a strong likelihood that Glover Landing will never correct these, that's as of the day you wrote your brief. And I'm trying to assess what's your basis for your current knowledge as to where the condo complex is as of this
The current knowledge is based on the BCAB order from July 2022, which says, okay, we're giving you this list of 9 things that you have to do. You have to do them according to certain time steps or time standards over a period of 545 days. Had to do with having somebody inspect the fire escape, having somebody determine what possibilities there were to fix it, to determine whether there was an alternative method of installing sprinkler systems, to obtain a building permit, to have the state approve that building permit. None of those interim steps were met. None of those deadlines were met. It wasn't until something like 485 days after that order, when the town was given 545 days to make sure this got done, that the town received, it received a plan to obtain a building permit. To borrow a phrase from what's been in the news recently, the concepts of a plan. And that was done, again, long after the deadline for that plan that had been established more than a year before. So my answer to your question, Your Honor, is that the testimony, the evidence of the conditions currently are based on the fact that BCAB ordered the town, ordered the town to make sure that Glover Landing did various things, gave them a year and a half to do it, and none of those deadlines have been met. Now, I'd like to point out as I'm sure my brother will, that the town appealed that BCAB decision. But I would refer this court to MGL Chapter 30A, Section 14, subparagraph 3, saying that those agency orders are not stayed unless the aggrieved party obtains a stay from the agency or a court, which hasn't been done in this case. So they were still on the hook to do those things, and they didn't do it. I would like to point out, Your Honor, common sense says that the town can't have it both ways. They can't assess the unit at close to $500,000, even half of what it's actually worth, and then fail to enforce its own orders and those of BCAB for Glover Landing to make the repairs that would begin to make the unit habitable again, all while collecting taxes as if the unit were habitable. Common sense also tells us that Mr. Mango can't even begin to salvage the unit, okay? An uninhabitable unit may be salvageable, but he can't even start to do that work unless and until Glover Landing cures the defects that make the unit legally uninhabitable.
So you have many references throughout the record appendix to other causes of action and other cases. This is just a yes or no question. Are your clients still pursuing other remedies in other litigation?
Yes.
Thank you. Okay.
I'd like to leave you with an analogy. If instead of going up the Gulf Coast, Hurricane Helene had come up the Atlantic coast and hit Marblehead Harbor and blew the roof off of Building 21, okay? And everything inside the building was drenched, destroyed by the weather. And then the condo association and the town did nothing to put the roof back on to correct the problems. In that situation, my argument to you is that the owners would have no obligation to try to salvage the unit or to pay taxes on the unit unless and until the conditions that created the uninhabitability, if I can use that word, of the building to go away, to abate those problems. One last point, as long as I have the chance. The town suggests that the orders, I already addressed that. The town's going to say that the orders from the courts and from BCAB are interlocutory, and that's not the case, and that's where Chapter 30A, Section 14, subparagraph 3 comes in. And I'd also have to indicate that it's been suggested that Mr. Mango has somehow obstructed the process that was supposed to have been completed within 545 days. That is false. There is no failure, no excuse for failure to meet these various deadlines. Now, that brings us up to the present. What really matters and what I'm here to convey to you is that it is clear from prior history and subsequent history that as of the assessment dates, the property was uninhabitable, unmarketable. Who would buy this white elephant, as I've said, and had no value to anyone? They couldn't even rent it out to somebody because they'd be just buying themselves a lawsuit. So for all these reasons, Your Honor, and I see I'm almost out of time. I'm sorry, one last thing. The Appellate Tax Board also erred by saying that comparable sales was the only method. And I would refer you to the Korea case that's in my brief. For all those reasons, Your Honor, Mr. Mango asks this court to vacate the ATB's ruling and to remand for further proceedings.
Thank you, Attorney
Thank
Rosenthal. Counsel for the Board of Assessors.
Good morning, Your Honor. May it please the Court. Matthew Preventure for the appellee, the Board of Assessors of the Town of Marblehead. This is a straightforward appeal from an agency proceeding in which the principal defect in the appellant's case is that they simply failed to provide adequate evidence to support the contentions that they advanced before the Appellate Tax Board, My brother spoke very eloquently about how he feels that the evidence that is contained in the record is persuasive. I would disagree, my colleagues from my office would disagree, but unfortunately it's none of our opinions that matter. It's the opinion of the Appellate Tax Board, which was not in fact persuaded by the evidence submitted. And so I think that under the standard of review that's applicable to the Appellate Tax Board, this court should accord it the substantial deference that it's due. Its view of the witnesses and evidence submitted should be given primacy in this proceeding, because that's what really matters. There is a failure of proof here. As many of the justices noted, there is more than adequate opportunity to submit competent evidence into the record. Mr. Mango had the assistance of 2 expert witnesses whose qualifications were not challenged. The problem for him is that those expert witnesses simply failed to submit relevant testimony on the ultimate conclusion that he was urging the Appellate Tax Board to embrace, that this unit has 0 value. I don't think there's any real legal issue in this case insofar as that the Appellate Tax Board did not hold that comparable sales are the only method of proving this. They said you did not submit any evidence of comparable sales. Similarly, you did not submit the opinion of a structural engineer who said these defects are present in this unit, they impair its operation, they would require X kind of work to correct or remediate. Secondly, I think if you look at the Appellate Tax Board's finding of fact and report of its decision, it makes reference to a comparable case that I think is very instructive, and that's the Christopher Smith versus the Board of Assessors of Hatfield. And in that case, you have a pretty similar scenario. In that case, I would submit to you the facts as presented to the Appellate Tax Board were even more frank and obvious. I don't even know that they would require an expert witness to quantify. The property was in an obvious state of disrepair. It was clearly structurally unsound. But in that case, the appellant before the board still did not submit any evidence as to what the cost to remedy that condition would be. And without that critical data, the board is without any evidence upon which it can rely to establish the lower valuation that my brother seeks to find out here. He's asking this court to sit in as the finder of fact and substitute its judgment for the evidence as the board saw it. Because we actually don't have anything in this record. There is nothing that establishes any value lower than that was found by the assessors for the town of Marblehead.
Go ahead.
Do you dispute that as of today, there is still no code-compliant second means of egress?
Not at all.
So for 9 years, I mean, that's atrocious.
I'm not going to defend that.
That strikes me as utterly unacceptable. Town has to do better than that, don't you think?
I think the town has issued...
Town and the condo, both.
The town, I agree with you. The town has issued repeated orders and has been litigating with the condo board to try to get compliance. But I would also submit to you that an equal
For 9 years.
An equal part of that equation, Your Honor, is that Mr. Mango has a private right of action against the condo board. If these are common area issues that are outside of his control, then they're clearly within the control of the condominium board of governors. He has every right as an owner of a unit within a common structure to bring an action to compel them to conduct mandated and necessary repairs. If he has not done so, that's his choice. Now, I know the town has been working and been trying to bring successful enforcement actions against the condo board, but he equally has a private right of action that he can litigate and that he can bring forward. Just as he's been litigating this tax appeal, he has every right to bring an action to force them to maintain the areas.
And perhaps there's blame to go around, but it really does not paint the town in a good light, to the extent that there are issues in this record that are undisputed.
I think that we know from the record that was before the board, it's clear that there's been a long-running history of difficulty in getting this property into compliance. I don't dispute that. But what I will tell you is that none of it directly undermines the assessment that was arrived at for the property. As has been noted, the assessment has been decreased. It's been decreasing for years. And in fact, in this case, Mr. Mango applied for an abatement of taxes, received an abatement of taxes, and his contention before the board was it wasn't enough of an abatement. I can't settle for less than you gave me. It has to be 0. And so I think the question for this court is whether he's carried that burden of showing that 0 is the correct number. If 1 cent is too much taxes for this property.
But I think the appellant's contention was that it was not his burden to establish 0, simply to establish that the assessment of about $500,000 was inaccurate.
I think that's an unworkable standard, frankly, Your Honor, because I think that means that if he says it was overvalued, to what degree? There's no way to work that standard in front of the appellate tax board if an applicant or an appellant before the board doesn't have any burden to establish to what degree, in some fashion, there was an overvaluation.
Is there anything to support a $500,000 valuation?
I
to
think
support it.
there is. I mean, this is a waterfront condominium in Marblehead. It obviously has substantial value. And the fact of the matter is that there are other inhabited condominium units in this. You know, my brother could have submitted evidence that those units weren't marketable at fair and competitive market rates. He could have indicated that because of the cost of remediating this unit, that there is no residual value, even though it's in a damaged and currently, let's stipulate for the sake of argument that it's uninhabitable. Even then, the property still retains residual value. That's still taxable. It can still be reflected in an assessment.
Well, Mr. Mango did present Jeffrey Klein's testimony, and he's a real estate appraiser, right? And he said, well, he said the unit likely had zero market value. He didn't actually offer an actual appraisal, but he said that any appraisal of the unit would be unreliable. And I didn't really see the appellate tax board kind of engage with that directly. They just sort of said, wow, it's unsubstantiated view that the unit was uninhabitable, but sort of this opinion that it's really impossible to come up with an accurate appraisal given all these factors. Shouldn't the appellate tax board have sort of engaged that a little bit more?
I think it did, because I think if you look at what Mr. Klein said, what he actually said before the board was that I cannot come up with a value for the unit because I do not know the cost to correct these items. And I mean, that's a common sense understanding. I mean, if you have a piece of property and there's a structure on it, the structure is decrepit, and there are actually costs because the only thing to do is take down the structure. That means that the value of the property is diminished by the cost to remove the structure and potentially replace it. That's not what's present here. We don't have that cost analysis, and that makes perfect sense as to, I can't tell you what the value of this condominium is, because if it's worth $1 million, but it requires $1.5 million of work to put it back into service, then it has negative value. He simply testified at the board that he didn't have an adequate basis to form a reliable expert opinion on the subject. And that's why I think the board looked at him and said, we'll take your testimony for what it is, but you concede that you can't give us a hard number. And without that number, the appellant put forth nothing upon which the board could rely to find that there was an overvaluation of the unit.
What about the issue of insurance? I guess Mrs. Mango testified that they were unable to get insurance for the unit despite working with an insurance expert and contacting 5 other insurance companies. And the board said, well, they didn't exhaust their options. They didn't go to the Division of Insurance website and look at those options there. But I guess I'm not sure what level of evidence is required to establish that a property is uninsurable. You can always say, well, you should have tried more insurers, but at some point, when does a complainant present sufficient evidence to establish that they can't get this unit to be insured?
I think you could easily bring in a question on insurability through an expert witness. I think you could demonstrate more forcefully. You could even subpoena in the people that you did have these conversations with. But I think all that you have from Ms. Garth is that she made some efforts to try to obtain insurance on the property. I don't think the proffer that was made in this case is sufficient to meet that burden, whatever it might be in a different case with different facts and an alternate trial strategy before the appellate tax board.
So they could have had an insurance expert testify that it was either uninsurable or, if insurable, here's the cost, and it's prohibitive.
Exactly. I think that that's something they very well could have done, similar to the way that they brought in a structural engineer but only offered an opinion about the fire egress catwalk. What this case is really about, as my brother spends most of his time in briefing and argument upon, is the presence of water infiltration, roof leaks, common area maintenance problems. We don't know how all those are happening. There's nothing in the record that indicates the degree of damage to any reliable quantum. We don't know what would be involved in remediating these issues and restoring the property to a pristine condition. And that's really the heart of the appellate tax board's decision.
So you're saying that the fact that these haven't been remedied in 10 years isn't an indication of anything because we don't know why.
I think that what the appellate tax board's rule is, and this is the way they interpret the statutory mandate they have to determine what the fair cash value of a property is. They interpret that in a case of a damaged or disreparable property,
What you need to do is you need to both establish what the value is, and then you also, if you want to tally the costs that would be associated with repairing the property, you need to provide some evidence of what those costs would be. I don't think there's any hard and fast or categorical rule about what form that evidence would take. I could see it being brought in through a contractor that had been asked for a quote. I could see multiple quotes being entered into evidence. I could see a structural engineer stating that you would need these, and because I have a familiarity with cost estimating as part of my project experience, it would cost X amount. There are a variety of different ways you would do it, and I can't tell you what weight the appellate tax board would assign to any of that evidence, but I can tell you that no such evidence was present here.
Anything further?
So I think, and in relation to this, I similarly, I don't find this to be a legally complicated case. I think by and large, questions of fact are for the appellate tax board, which sits as the finder of fact. To the question that this court reviews to determine whether there is substantial evidence, I don't think there can be any question that there was substantial evidence before the board. This is not a circumstance in which the board prevented Mr. Mango from bringing in a lot of evidence and then told him that he failed to meet his burden. Instead, it allowed him to get in virtually every item of evidence that he wanted to present. It considered all that evidence, and it simply made its own independent determination as the body within the Commonwealth that has expertise in adjudicating tax matters, that they had failed to persuade the board by the presentation of what evidence that they had adduced. So I think for all of those reasons, Your Honor, I think the board's decision is unaffected by any error of law, is based upon an adequate factual record, and reflects the sound judgment, credibility, and weight afforded to evidence before the board. And for that reason, I ask that the court affirm it. If there are no further questions, I will rest on my brief.
Seeing none, thank you. Both of your clients have been well represented in the cases submitted. Calling our final case on the list, docket 23P1393, Curley v. Ternulo. And we will hear first from counsel for the appellant, Attorney Bixby.
Good morning, and may it please the court. Dominic did have an estate plan, contrary to finding number 26 in this case. He had a prenuptial agreement, and it specifically said nothing to wife number 2. The purpose of that prenuptial agreement was to protect the children. And in that prenuptial agreement, Attorney Lyons, draftsperson in this case, represented Dominic. In addition, Dominic had a trust, long-standing trust. He had a deed. These constitute an estate plan. That's what an estate plan is. So in 2019, when Attorney Lyons and wife number 2 had lunch, that's totally inappropriate. You don't do that. When you're an attorney and you represent one side in a case, you don't go out to lunch with the other side, particularly if one of the purposes of that is to discuss undermining and changing the prenuptial agreement. Now, what this case is about a deathbed will, and that's the right term in this case because Dominic died in that bed the next day. But it also involved a deed and a power of attorney, a beneficiary change form, and in fact, that same day, that power of attorney was signed and used to change beneficiaries. And that document was erroneously dated May 29th instead of August 29th. This is the kind of thing that was going on here, and you got to look at it as an accumulation. The result was this minor child was disinherited, not protected. So in this case, where there's every red flag that we estate planners look for, don't set the bar too low. A will is more than just a piece of paper. On the recusal issue, the judge himself raised the issue late in the case.
Where in the record did the judge raise the issue? I don't see that transcript before us. I don't see an
I
affidavit.
don't recall, I might have been at the pretrial conference, and he said, I know Attorney Lyons.
Where do we see that? I understand, it's in the motion that you filed.
Yeah.
I don't have perhaps I'm missing it, but I didn't see a copy of that transcript, and I don't see, for example, an attorney affidavit describing precisely what the judge said. So
I think the only basis of that I recall would be in the motion. In other words, he raised it.
Okay, it says that she raised and said, I have familiarity with these attorneys, or with this attorney.
With this particular attorney, that's correct. Now, normally, when a judge raises an issue like that, and he's essentially asking people, does anyone have a problem with that? And if somebody does, then the judge recuses himself. In this case,
I wouldn't say that's necessarily my experience with that. What is the evidence that the judge had a relationship with this lawyer outside of court proceedings, if any?
He said he knew her, he knew her husband. It's not.
Where do we see evidence that he knew her husband?
I don't know. I'm going back. I was the one that was trying the case, and so.
I'm not saying you don't have some very interesting, and excellent issues here. What I am saying is, if we were to agree, at least with what you've written here in terms of recusal, then there would be an awful lot of judges having to recuse themselves from thousands upon thousands of cases every day. I think that's a difficult sell, but you can use your time to tell me why I'm wrong on that, or you could move on.
I will, Your Honor, because the difference in this case is this lawyer was the key witness. In other words, in the one common thread in a will contest case is that the real key witness isn't around to testify. So we have to use others, and the drafts person is often the key witness, the one who was involved, the one who had any communication.
And the other witnesses who were there for the signing of and the execution of the documents.
Correct, but the witnesses to a will virtually never have any involvement with the procurement of the will. They don't know what the will says. They don't know what the discussions are. They're there, they see somebody for 5 minutes, that's it. So they're not that important, but yes, they do testify in will contest cases. But in this case, it was enough that we were concerned, we raised it. Again, the judge denied it, but then in the course of the case, he credited this lawyer with a lot more than we think he should have. So let me get to that. The judge got wrong.
Are you still on the recusal issue, or are you moving on?
I'm moving on.
Then I just have one more question, and that's, do you have any authority for the proposition that a judge should recuse himself or herself in a situation like this, where they have no relationship outside of familiarity with that lawyer as a practitioner? Is there any case on point?
No, it's just the judicial conduct and
Understood.
and that and the.
Thank you.
Now, in this case, the trial judge got the burden of proof issue wrong. The second wife, as the petitioner for probate, had the burden to prove capacity and lack of undue influence once those issues were raised. At the summary judgment stage, we don't have to rebut the presumption of capacity. There were medical records in this case. There were affidavits of objections. Those are generally sufficient to survive a motion for summary judgment because those are issues that need to be tried in the case. And in this case, what did those medical records show? Boy, among other things, markedly declined functional status, fatigue, anxiety, inability to feed himself, limited mobility. They showed he was, at the time this will was being signed, he was on morphine, he was on Ativan, he was on Remeron. All of those have primary side effects of drowsiness and dizziness. He was in significant pain. He was suffering from confusion, weakness, concentration difficulties. And on August 29, the date he was signing this, records show he was lethargic and drowsy and on, quote, continuous morphine, end quote, and he died the next day.
Would you agree that so I just want to make sure I understand the universe correctly, that the evidence of lack of testamentary capacity that was put forth is contained in, number one, the medical records, and number two, the affidavits of objection of Carmela and John?
Yes.
Okay.
And that was sufficient. In other words, to the extent somebody says, oh, well, you should have had a medical expert or this or that, you know, at the summary judgment stage, that's not necessary and often the case. And this is the world of reality. When people are challenging a will, they don't have the money yet. You know, medical experts are very expensive. And so they are usually procured only when necessary. And in this case, we had very clear, lengthy medical records, which the judge said he would review. And so that's the way that was. On the issue of undue influence, which this case was tried on, there was, in fact, an unnatural disposition. The children were cut out of this will, all the children.
Where in the case law do we find the correct definition of unnatural disposition? What's the best guidance you can provide us?
Well, the best one is, you know, the people who are considered the natural bounties of one's affection, which are generally children, particularly in a case where there's a second marriage. So it's when something like that doesn't happen. In other words, it's a change of what would normally happen in the real world. And in this case, the real world was that there was a prenup in which he had clearly stated, not that he did, he and his wife had clearly agreed that she was waiving her rights under his estate. And that was
Does it matter that the second wife, that he purchased the house after they got married, kept it in his own name, and she and their son lived in that house until his death? Does that matter at all in terms of our analysis?
It matters in this respect, Your Honor. Number one, it's consistent with what Dominic did during that entire marriage, up until that August 29th, the day before he died. He kept everything in his name, and he was consistent on that, and he knew what he was doing. He was a smart businessman. And doing it and having that prenup, which he relied on, meant that 1/3 of his estate was going to go to that minor child. Instead, when this deathbed will was done, along with what I'll call the deathbed power of attorney, and the deathbed new deed, and the deathbed change of beneficiaries, that minor child got 100% disinherited, and everything went outright to wife number 2. And the Attorney Lyons, admitted in her testimony during this case that she did not explain to Dominic that a spouse or widow can get remarried, things can happen. There's no guarantee that a nickel's ever going to go to that minor child. This was not a way to protect a minor child. The way you protect a minor child is you set up a trust. We sometimes call it whether a marital trust, whatever, so the wife has the benefit during her lifetime, but it can't be grabbed by someone else. And that's the way it's done. But Attorney Lyons had no clue how to do that. Again, this is by her own testimony. She was not an estate planner. And her services were procured through wife number 2, who said, wrongly, Dominic doesn't have an estate plan, I'm worried. He did have one. And Attorney Lyons got inserted into this on the day or two before Dominic dies, no engagement letter, no drafts, no nothing. First, she shows up, here's a deed. He never asked for a deed. And then comes back, here's a will, here's a power of attorney, here's a change of beneficiary, all of that stuff. But none of it included what would have been the appropriate document if the intent was to benefit and protect the minor child as well. It would have included a trust.
Just for my background, you say the 1/3 interest would have gone to the minor child. That's under the terms of the prenup that was done, or what was the mechanism that was going to provide before the events of August 29th that a third share would go to the minor child of the second wife?
The prenup specifically says that she, the spouse, waived all rights of inheritance and intestacy. So in other words, if he died, as his plan was, with no new will, then it goes outright to the children. They are the, by law, by operation of law. And he would have gotten his third, and yeah, it could have been put under guardianship, it could have a lot, but that was the intent to protect.
Attorney Lyons was the attorney who worked with Dominic and set up this, so she understood how that was going to work.
I would presume so. She was the attorney for that prenup and set it up so that it said specifically that these two, and by the way, when that prenup was done, he had known this woman for less than 2 months. In any event, he was susceptible, so this was an unnatural distribution, as I pointed out. He was susceptible, he was elderly, he was hospitalized, he was immobile, he was dying. She had the opportunity to come in and take advantage of the situation. It's admitted he was 100% dependent on others at the time.
When the judge said that he didn't think there was a genuine issue of material fact as to testamentary capacity, he said, well, there's all these percipient witnesses who testified that Dominic was in rational state of mind, and you have medical records on the other side. That's the battle here. And I guess, do you have any thoughts about sort of when you have actual witnesses who are observing a person's functioning versus what's reflected in a medical record that's somewhat secondhand account? Is that still sufficient to create an issue for trial?
The answer is yes, because...
Your time is up, but please answer the question.
Sure. We not only had that, but we also had testimony from family who was there observing. There were other people there. And if I could just have one more minute to just finish up, because this is important.
We will give you exactly 1 minute. Go ahead.
Thank you. He was disinherited, not protected at all. And Attorney Lyons was wrong in her conclusions that what she did would take care of the child. No, what she did would completely disinherit the child, and did. She just wasn't an estate planner. So there was an estate plan, there was plenty of evidence, and it's referenced in the findings as to in what bad shape Dominic was in. There is finding 72 where the wife number 2 really just lied about whether or not he did, knowing about whether he had a will, and therefore I think it's appropriate to remand or reverse this one. Let's not set the law on wills, and particularly deathbed wills, this low. The elderly are already taken advantage of too easily all the time in financial matters, and this is an example of sticking a piece of paper in somebody who clearly could not read it, and he didn't read it, and that's admitted in there. And somebody just told him, here's what it says. Maybe he understood it, maybe he didn't. I didn't think so, but in the world where you can put a piece of paper in front of an elderly sick person and they'll sign just about anything, this is not the standard we should have in Massachusetts. Thank you.
Thank you, counsel. Attorney Stetson.
Good morning, Your Honors. Robert Stetson for Fabiana Ternullo. May it please the court. The court assessed all of the medical records and the witness testimony at a trial and concluded, based on all of the evidence, including numerous credibility determinations, that Dominic Cernulo was aware of and understood the contents of the will. That's at page 23 of his findings.
Wait a minute, the testamentary capacity was decided on summary judgment, correct? He said there was no genuine issue of material fact as to that issue, right? So that wasn't tried.
That is correct. However, the susceptibility issue was a necessary element of the undue influence claim. So issues of any capacity, vulnerability, his cognitive functioning, that was all fair game. There was nothing limited at the trial in terms of the judge's assessment of the medical evidence, the percipient witnesses that went to his cognitive functioning. And I think, speaking to the summary judgment issue on the medical records, as the judge found in the summary judgment record, all support that he had adequate cognitive functioning for purposes of testamentary capacity. He went through the medical records. August 27th, the date of admission, he was screened, no delirium, awake, alert, negative for confusion. That's in the record. August 28th, the date of the deed. Following a 90-minute consultation, the medical evidence was awake, alert, oriented, concerned about his son's well-being. August 29th, the date of the POA and the will. Oriented, follows commands, spoke to a spiritual counselor in earnest. There was deliberation and thought. There was cognitive functioning. And all of that was sufficient for summary judgment purposes in cases like the Maimonides school case.
There was evidence, though, between the affidavits of objection and the medical records. There was evidence stating that now the decedent there was confusion, in pain. I'm thinking of the statements from the two children regarding their observations of him. Why is that not enough at the summary judgment stage to create a genuine issue of fact or an issue of genuine fact?
The one reference in all of the medical records to confusion was on the morning of August 28th, just as Dominic Cernulo had woken up. That's right in the record. The evidence is that Attorney Lyons did not come to visit him until the afternoon. By that point in time, the medical records show after a 90-minute consult that he was alert, awake, and concerned about his son. There is negative for confusion, oriented to person, place, and time. So just like in, for instance, O'Rourke or Urban, where there was a reference to confusion in the medical records in both of those cases, summary judgment was still granted in both of those cases. And speaking to the other strong reason why I don't think there was a genuine issue of material fact, it is with respect to the percipient witnesses. The percipient witnesses who were there, Attorney Lyons, Chief Lyle, Sergeant Vinci, they weren't just there, looking at, someone that they've never met before and for 5 minutes are just there looking at a signature. They spent an hour with him. All three of them had known him for decades. There was conversation back and forth, and that was both in the affidavits as well as at trial.
Right, but the issue at summary judgment really isn't what evidence was in your client's favor. The issue is, was there any evidence to create a dispute of fact?
Was there sufficient evidence to create a disputed fact to overcome the presumption of capacity? And this evidence in Urban.
And what's the best case on that? Because I'm looking at, is it Maimonides or?
I think that the two best and most similar to this scenario are Maimonides School and Urban from last year.
Okay.
Those are the two best, and the evidence is quite similar in both of those instances. But the other thing, I'm sorry, Your Honor.
Well, at some point I want you to address, I think one of Mr. Bixby's strongest points, which is that, undisputed that Dominic didn't read the will, didn't have it read verbatim to him, but it was explained to him in some sense, and that he really clearly wanted to protect the minor child, the second wife. And I think it's a very powerful argument to sort of say these changes were bad for the minor child. They took away effectively his third share and took that away entirely, and that reflects some fundamental misunderstanding by Dominic at the time. Do you disagree with that? I'm just curious in your response.
Yes. And that was an argument that was made several times to the judge, and it's inaccurate because there was this trust that had a large, it's disputed how much the estate actually owns of this trust, but the trust owned a commercial property. And based on what the contestants have said, is it's a third, a third, a third. Each of them own a third, including the estate. So if what the contestants say is true, then the minor child would only get a third of the largest asset in the estate and would essentially be put out on the street from the home that he's lived in throughout his entire life because he would only have a third of a share of that, and his mother, who he lives with, he's only 12 years old at the time, would have no shares. So I think it's kind of the reverse. It's that, you know, the idea here was that there was a true relationship for 13 years with Fabiana Ternullo. She took care of the son. She still does. They still live together. And the expectation was that that would continue in the future. And so Attorney Lyons, who has known him for a long time, came to that conclusion with his assistance. And so I hope that addressed your question, Your Honor. Two other points just quickly on incapacity. One is medical evidence. I do think that under Sparrow versus DeMonico, you need to present something, and they presented nothing. And I think it gets lost in the shuffle a little bit, but Fabiana Ternullo did present a medical expert on top of all the medical records and on top of the recipient witnesses, and Dr. Ross, through his affidavit, testified pretty clearly that there was ample evidence of testamentary capacity. And I did just want to hit on that, the point that I started with here, because I don't think there is any basis to reverse the trial judge's findings in the undue influence trial. And he concluded that Dominic Ternullo was aware of and understood the contents of the will, even if there were theoretically a disputed issue of fact. If this were sent back down on the incapacity issue, I believe that that finding would be dispositive of the capacity issue in the lower court.
You aware of any case that says that we can take a finding at trial and apply it to a summary judgment motion that was previously denied?
I looked. I can assure you of that. I was not able to find.
I don't see how we could do that. We have to review the record as it existed at the time, and we're limited to what is in the statement of fact and the exhibits attached thereto.
However, what
I don't think we conduct a harmless error analysis in the context of summary judgment motions.
Your Honor, I agree with you. However, the way that I've looked at the analysis is that if by some chance there was a sufficient disputed issue of fact, it would be, but you upheld the undue influence findings because of trial, that would present the law of the case, which applies to both issues of fact as well as legal conclusions. And that's how I would think it through from a practical perspective.
Right.
I agree with your observations.
No, we're not going to find a case that says that, right?
You're not going to find a case that says that. If I could speak to the undue influence issue briefly, the findings must be upheld, as Your Honors all know, unless if there is any rational view of the evidence to support it. I think there are 4 independent reasons to support the conclusions here. Number 1, burden shifting does not apply. That was an argument that was made below as well as on appeal. It doesn't apply, whereas here the beneficiary was not involved in the estate plans at all. And that's straight from the Urban case again, which is a case that we rely heavily on.
When you say that the beneficiary was not involved in the estate plan, that's predicated on the judge's finding of fact in that regard.
That's exactly right, Your Honor.
Because that was disputed at trial, obviously.
That was disputed at trial, and the court heard all of the evidence from all of the recipient witnesses. There was one witness that said she thought that Fabiana was in the room at the time that the will was executed. That was rejected as not credible.
Right, but she did meet with Attorney Lyons for dinner not too long before the decedent's health went downhill.
It was many months before, and that was thoroughly explored at the trial. It was just a dinner. There was an offhand conversation about whether or not there was an estate plan in place. Fabiana's, she said she didn't think so.
Have you ever seen a case where an attorney shows up on their own volition to someone's, for lack of a better term, deathbed, and comes in and says, hey, I brought all these things, let's drop a will?
Well, what the testimony was that Attorney Lyons knew that the property was not in Fabiana's name, and that could present an issue down the road. And so she prepared the deed in the event Dominic wanted to sign it that night.
Okay.
That was the 28th.
But now answer my question. Have you ever seen a scenario like that I just described?
I have not. No, I have not personally. And I did not see it in any of the cases either, Your Honor. But I think it goes to the relationship here and why this was an issue for the fact finder evaluating all of the testimony could reliably decide based on the credibility determinations. Myra Lyons wasn't just an ordinary attorney. I mean, they had worked together for about 15 years. She was involved in a lot of different aspects of his business over the years, including the prenup, but that wasn't all. And so when she showed up that night, it wasn't, hey, here, sign this. It was, I prepared a deed. Do you want to sign it? You know, yes, I do. Okay, do you want me to do anything else? I want you to leave everything to Fabiana and Mimo, which he reiterated that many times over the course of that 2-day period. So she went back to her office on the 28th, prepared the documents hastily because, you know, he was declining. But this was not, also, one other point, this was not an elderly man, which I heard during the argument. He was 67 years old. He was struck down by mesothelioma, and he was someone that was still in the prime of his life, but for this cancer that took him. And I think that that's another piece that goes to both his capacity and the fact that he was making some independent decisions during these conversations with Attorney Lyons. Sticking with undue influence, there was no susceptibility here. Because Attorney Lyons was acting as his independent lawyer under Urban and Rempalakis, that fact has been considered dispositive. And then in terms of unnatural disposition, again, that's an issue of fact. I mean, dating back 100 years to the Cranston versus Hallett case, it's been found in almost strikingly similar circumstances where second wife gets the estate to the exclusion of adult children. That was found not to be an unnatural disposition. With the very limited time I have left, I could address the recusal issue if your honors would like. I'm willing to rest on my briefs then.
Seeing no further questions, thank you. This is a difficult case. We appreciate the excellent advocacy and the case is submitted. Thank you both.
Thank you, Your Honors.
And that concludes our session.